Welcome to Employment Bite. In this series, our London employment team will provide bite-sized overviews of some of the key developments surrounding the employment law landscape in the UK. Whether you're an employer or employee, join us for a discussion navigating the dynamic world of employment law. I'm Anvita Sharma, and I'm joined today by Joe Broadbent. Together, we're going to explore the new rules on flexible working set to come into effect in April of this year. We'll also touch on the new ACAS Code of Practice, which is designed to offer employers guidance on handling flexible working requests, and discuss recent tribunal decision Wilson versus FCA, which has received significant attention in the employment world. So let's kick things off with the April changes. Joe, could you walk us through the key points that employers should be prepared for?
Yeah, so I think there are probably four main issues that employers need to keep in mind. I think firstly, and most importantly, the right to request flexible working becomes a day one right, so employees can ask for it as soon as they start work. Secondly, employees can now make 2 requests each year instead of just one, as has been the position until now. Thirdly, employers have got to consult employees before refusing a request. And then finally, the time period for deciding a request is reducing from 3 months to 2 months. And even if you're going to offer an appeal, the appeal has got to be completed within that 2-month period as well. So it's quite a truncated time frame. That means it's really important that everybody knows from a practical point of view who's responsible, for example, for arranging meetings, to make sure that the employer is in a position to complete it within that period. Now, that's the broad overview. We're going to drill down into the detail a little bit now. Anvita, can you explain to us how the 2 requests a year right is going to work?
So the key point here is that requests aren't reviewed on a calendar year basis, but rather in any period of 12 months. And within that time frame, an employee is limited to a maximum of 2 applications for flexible working. Essentially, employers look back from the date of a request to see how many requests the employee has made in that 12-month period. Another point to note is that the clock does not reset in April. So if an employee has already made a request in the run-up to April 2024, that will count towards their 2 requests within the 12-month period. Additionally, an employee cannot submit a second request while the initial request is still being considered. So that's a brief summary of how the 2 requests and 12-month period will work. Now, Joe, when you discussed the overview earlier, the thing that really caught my attention was that employers must consult an employee before refusing a request. What do you think that would mean in practice?
The practical implications of that are dealt in the revised ACAS Code of Practice on flexible working. In summary, employers need to invite employees to a meeting to discuss the request. And that's really an opportunity for both parties to understand what the employee is looking for and why, look at whatever benefits there might be for both parties, and also think about any practical steps that would be necessary to accommodate the employee's request. It might also be an opportunity to discuss alternatives if the employer doesn't feel it can agree to what the employee has asked for, and that could agree a trial period, for example, as well. Essentially, it reflects the recommendation in the ACAS Code of Practice to approach flexible working requests in a positive and open manner. Sometimes to date, employers have viewed their response to flexible working requests very much in binary terms. They felt they could only refuse or accept them. And I think the code makes it clear that that isn't necessarily the position.
I agree, but I do think it's worth noting that when it comes to the grounds for refusing a request, they remain consistent with what they've always been. Factors such as increased costs, potential detrimental impact on performance or quality, and the inability to meet customer demand continue to be valid reasons for refusal. So that leads us to discuss the reasons an employer must provide when refusing a request and the level of detail they should offer. Joe, would you mind elaborating on those?
In that context, theoretically, at least, it's possible for an employer simply to state the statutory reason that they're relying on. I'm not sure that's the most effective strategy for two basic reasons. The first is that in the ACAS Code of Practice, the recommendation is that employers obviously give the reason for refusing, but also provide any additional information that it will be reasonable to give the employee so that they understand the reasons for the refusal. So I think putting a bit more flesh on the bones and not just baldly stating the statutory reason is going to help show that you've considered a request reasonably. Possibly more importantly, in practice, employers are going to be more worried in some cases about facing an indirect discrimination claim than they are a claim under the flexible working regulations. Being transparent about why you're refusing a request may help make such claims less likely, or at least it may help persuade a tribunal that your refusal of the request is objectively justified. Should an employee bring a claim? Anvita, is there anything else before we move on that you think employers should be thinking about at this point?
Absolutely. I mean, I would firstly say that employers should ensure your policies clearly outline the information required from employees when making a flexible working request. Whilst there's no change from the previous code in this regard, it's worth noting that employees no longer have to specify the potential impact of the change on the employer and how it could be managed when submitting a request. Policies may need to be revised to reflect this. The code also makes it clear that it would be good practice to allow an employee to appeal, even though there's no statutory right to do so. That was also the position in the 2014 code, but there is much more detail now about how the appeal should be handled, which employers will want to review and then refresh their policies if necessary.
That really covers off the legal changes coming into effect in April. As you mentioned, Anvita, at the outset, there was a recent tribunal decision that generated quite a lot of excitement in the employment law world. Can you remind us of the facts of the Wilson and FCA decision?
Yes, it has generated quite a bit of excitement, which is unusual for an employment tribunal decision. That's probably because it's the first case on flexible working requests in the context of hybrid working since the pandemic. The background is that Miss Wilson had been working completely remotely and requested to continue doing so indefinitely. However, the FCA, like many others, had a hybrid policy requiring 40% of her time in the workplace. Miss Wilson's request was based on her belief that she could continue to work effectively on a fully remote basis. However, the FCA denied her request, citing concerns about the potential impact on performance. They highlighted her seniority and the necessity for in-person training and the supervision of her team. Arguing that some tasks could be better handled face-to-face, they ultimately declined her request. Ms. Wilson claimed that the employer relied on incorrect facts, contending she had successfully worked remotely since 2020. She argued this invalidated concerns about her performance suffering without office presence.
And in that respect, Anvita, I think it's pretty noteworthy that when the tribunal rejected her argument that the FCA had based its decision on incorrect facts, the tribunal did recognise the limitations of online communication platforms like Zoom, and that those are not necessarily well suited for swift exchanges in a sort of fast-paced working environment. Collaboration can be much more difficult when you're working purely remotely. And I think that definitely influenced the FCA's concerns about the possible impact of fully remote working on performance. What are your views on what made this an interesting decision?
I think what is clear from the decision is the tribunal is not going to only focus on past performance, but also on potential future impacts of remote work. While I wouldn't regard the decision as groundbreaking as such, it is a close examination of hybrid working policies post-pandemic and how an employer can deal with these requests against, frankly, a background of a changing world of work. But at the end of the day, this is only an employment tribunal decision, and so it does not set a precedent for future cases. I don't believe it will have significant implications for future claims, but what's your take on it, Joe?
From my point of view, another point to bear in mind was that Miss Wilson didn't raise indirect discrimination arguments based on a protected characteristic, and she didn't argue that she needed reasonable adjustments because of a disability, for example. Had she been able to pursue that route, the employer would have had to demonstrate that its requirement to be in the office at least some of the time was a proportionate means of achieving a legitimate aim. And that would have been a significantly higher hurdle than simply demonstrating to a tribunal that its decision was based on accurate facts. It's really important that employers don't see this decision as some sort of blanket determination that it's okay to refuse requests for fully remote working, regardless of someone's individual circumstances. Just picking up that indirect discrimination point in a little bit more detail, it's possible that in the future, employers are going to face indirect discrimination claims from a wider group of potential claimants than has been the case until now. Can you just talk us through why that might be the case?
Yes, there's been a recent amendment to the Equality Act aligning it with European case law. This essentially broadens the scope of employees who are eligible to file an indirect discrimination claim when a flexible working request is denied. It's quite a technical amendment, but essentially, if a provision, criterion, or practice puts those who share a protected characteristic at a disadvantage, anyone who experiences the disadvantage can bring a claim, even if they don't themselves have the protected characteristic. We may see more indirect sex discrimination claims from men whose flexible working requests have been refused as a result of this change. Thank you for joining us today. We look forward to seeing you in the future on our next bite in this series.